Hi friends, and welcome to the 6th virtual class on Contracts Act 1872. This is Lokesh Pathak with you, and today the topic which we are going to discuss is conditions of the void contracts. Uh, in our recent lectures, we discuss about void contracts, and we discuss about the some of the conditions where some of the contracts are found to be void. The definition of void contract, which we have already discussed, it was mentioned in section 2G of the Contract Act, and it says that an agreement which is not enforceable by law is a void contract. We also discussed that there are certain conditions related to lawful consideration and lawful object, which are mentioned in section 23 of the Act, which, if they are not satisfied, or if we came to know that the consideration and object is not lawful as per those conditions, then the contract becomes void. So apart from the stipulations made in section 23, there are some other references in the Contract Act which determine that a particular contract is void under certain conditions. These conditions are mentioned from section 24 to 24 to 30, and also pertaining to the contingent contracts, which are conditional contracts. The void contracts are defined in section 32, 36, and further in 56 in relation to the impossible acts. So we'll quickly have a look on what are the conditions and when the contract can be void. Coming to section 24, starting with it, any agreement is void if the consideration and object is unlawful in part. So section 23 about the lawful consideration and object, and while 24 talks about the unlawful consideration or object in part. So section 24 says that it's not necessary that whole of the consideration or object is unlawful. Even if part of that is unlawful, the contract will be void. Section 25 says that an agreement without consideration is void. But there are certain conditions under which an agreement without consideration is not void. And there are such three conditions are there in the Contract Act. First condition is if the agreement is registered in writing. Means if you are not having any consideration in the agreement, but if it is registered in writing, then it can be valid. Another condition is if a promise to compensate, if the contract is meant to promise to compensate for something which is already done. In that case, without consideration, the agreement will not be void. The third exclusion is if the agreement is meant to pay for a promise which is related to any debt which is barred by the limitation law. So as per the limitation law, there is a stipulation, there is a specified timeline to make the transactions. If that timeline is gone, and to make any adjustment and to make any settlement, if you want to have an agreement for paying any debt, then an agreement without the consideration is admissible. Section 26, it says that an agreement is void in restraint of marriage. It means if any agreement is made by which the freedom related to marriage is limited or restricted, then that agreement is void. Section 27 says the same thing with respect to trade. Means an agreement is void if it is in restraint to any trade or any lawful profession. Section 28 says the same thing with respect to legal proceedings. Means an agreement will be void if it restrains any legal proceeding or if it limits the freedom as per any legal proceedings. Section 29 says an agreement is void for uncertainty. Means the agreement, if its meaning is not clear, the agreement is uncertain and it will be void. Section 30 says that the agreement by way of wager is void. Here we cover all the wagering agreements which are depending on any bet. So such agreement will be void. Section 32 says that any agreement which is contingent, but it's contingent on an uncertain event, And in case that uncertain event becomes impossible, then such agreement will be void. Section 36 says that any contingent contract which is contingent on an impossible event is void. Section 56 says that an agreement to do an impossible act is void itself, from like what void ab initio, like void since inception. So you can see based on these points that agreements related to pertaining to section 24 to 30, 32, 36 and 56 are void. So this is an important point. This class is very important. It's a quick but important topic, that what are the conditions as per Indian Contracts Act 1872 which makes a contract void. So I hope this session is helpful to you. Thank you. Keep in touch. Bye.